You have the reins now. You can do what you want.
Anything I want, that's dangerous. I talked to Tana this morning for a few minutes and I said, did you guys get rain down there? And she said, no, we actually got not a lot, but a little rain, and we'll take anything. We'll
Yeah,
take
where are
anything.
you at?
We're up in Ogden.
Ogden. Okay. That's where my brother lives.
And so we actually did get a little bit of rain. So
Maybe
it's
it'll
nice.
come our way.
I hope so. I hope so. So yesterday we did a client appreciation lunch at our Layton office, and it was a Hawaiian luau, and we had a food truck, and we
Yeah.
actually had Hawaiian dancers. And one of the girls that was the hula dancer, I was talking to her, and she's an agent, and she's an agent up in this area, but she's looking to move agencies.
Oh,
And she said, well, one of the places I was looking is Presidio. And I said, they're a great company. And I said, well, the one thing I know for sure is they value education. They
that's for
like to
sure.
educate they like to educate their realtors. And so I said, in fact, we have a class tomorrow. So anyway, I put in two good words for you.
Yay! Thank you.
Okay, I'm going to just run through some of the things. One of the things I wanted to share with you is, I don't know if you know how far reaching our offices are. So we have an office in North Ogden. We have an office in South Ogden. We have an office in Layton. We have a title plant in Layton. We have an office in Bountiful. We have an office in Parley's Way. We have an office in Midville. We have an office in Orem and an office in Spanish Fork.
Wow.
So what I'm saying is, wherever you have a transaction, we've got an office and someone to take care of you, and we would love to have your business. One of the things we have is a local title plant, which makes it really nice because we can kind of twist their arms if somebody needs something really quickly. I'm Jill Chandler. I am the state sales manager whose brain isn't working. So I'm away over the sales force. I've been in the business for about 25 years or plus. Your instructor today just happens to have the same name as me and sleeps with me at night, Mark Chandler. He is our corporate attorney. He has taught business law at Weber State. He's been in the business for over 30 years, and he's a really great teacher. So I'm going to turn the time over to him. I have one challenge to Vickie, Emily, Rami. Is that right, Rami? One thing I always say at a class is, I want you to walk away knowing something you didn't know or asking a question that you had thought about. So the best classes are interactive classes. And that's what Mark likes. He likes to hear what you have to say, or if you've ran into something or questions. So please be a part of the class, and anything that pops up in your brain, just unmute yourself and he'll be glad to talk to you. So here's the main man.
Can I say one thing real quick?
Yeah.
For those of you that are getting on a little bit later, we have the class outline in the chat, and then also the your sign in form when we're all done. And someone just asked me to resend it, so I just resent it again. Please let me know if it's working or not working, and if so, I can try and get it to work before the class is over. So, okay, thanks.
I sure hope Jill didn't offend anybody by that reference to us sleeping together. Is anybody offended by that?
I had
Although
some,
you actually put it that way.
I just had some questions about that when I heard it. I mean, what does that mean?
Yeah, we're under the same roof, so we're legal. Well, thanks, you guys. Good to see you again. Glad we could get our Zoom to work. We've only been doing this for over a year. You'd think that we would master it by now, but apparently not. So, and we're doing quite a few live classes, and so hopefully before too long we can get in front of you and see your lovely faces. So yeah, we got a small class today, so let's not stand on formality. Throw your questions out. Let's talk about whatever you want to talk about. The outline is on mechanics liens. It's 1 hour core, and I'll hopefully make it applicable to you. who works with new construction? Anybody? This is a real problem. This is a real problem with new construction, but it could also be a problem with rebuilds or remodels, those kinds of things. Anywhere, anytime there's new construction. I got a interesting call yesterday. I'm gonna turn this off, Jill. I got an interesting call yesterday, and it's one that I get occasionally from an agent who's got a transaction where she's got an investor who is going to buy a property, and well, he's got the property under contract, but he's going to fix it up and then flip it. But there is an existing debt on it, and he's afraid of doing a purchase right now on a seller finance because of the due on sell, and they're talking about doing a wrap and the due on sell, and but he wants to go ahead and rehab the property with his own money, put about $50,000 worth of labor and money into it, and then market it. And when he's got a buyer for it, then he'll purchase it and then flip it. Well, I don't like that arrangement. I don't like the arrangement where anybody goes in prior to actually taking title to a property and putting their own money into it. The problem is the transaction falls apart, and then he's got all this money and effort and labor into this, and he wants to be compensated for it. And what I've seen is people in that scenario then filing a mechanics lien to preserve their right to get paid. Well, who thinks that a person like that is entitled to a mechanics lien? From what you know of mechanics liens, do you think that a person that goes in and does work like that prior to a transaction is entitled to lien the property with a mechanics lien? What's your opinion from what you know of mechanics liens?
My guess would be possibly, simply because, I mean, obviously you can't enter a property without having some invitation to do so. So if you're able to spend days and weeks working on the property, it could be said that you were given the green light to do this work by somebody.
I think that is a good answer, a thoughtful answer. And I think that would go toward whether or not the homeowner was responsible for reimbursing the buyer for the work being done. If you know that somebody is improving your property and you don't object, or if you don't stop, I definitely think that there are legal remedies that would protect the person making the improvements to the property. I don't think it's a mechanics lien. I don't think that is the kind of person that is entitled to a mechanics lien. And so I just use that example to kind of springboard into the concept of a mechanics lien. And so a mechanics lien is a statutory lien, which means it's allowed by a Utah law. And whenever you have a statutory lien, you've got some very strict technical definitions of who's entitled to the lien and how the lien is to whom it's directed and how it's to be used. And so under the Utah code, let me just read quickly what the Utah code says. And it says, these are the people that are entitled to a mechanics lien: contractors, subcontractors, and all persons performing any services or furnishing or renting any materials or equipment used in the construction, alteration, or improvement of any building or structure or improvement to any premises in any manner, and licensed architects and engineers and artisans who have furnished designs, plats, plans, maps, specifications, drawings, estimates of costs, surveys, or superintendents, or who have rendered other like professional service or bestowed labor, shall have a lien upon the property upon or concerning which they have rendered services, performed labor, or furnished or rented materials or equipment. Long way of saying, I think that the mechanics liens are meant for licensed contractors, subcontractors, laborers, material men, people that provide professional services like architects and people like that. So a lay person, unlicensed, who goes in and does work, I don't think the statute is intended to protect that person. And so your neighbor kid comes over and cuts your lawn and he doesn't get paid, or he comes over and digs a hole for you and plants a tree and he doesn't get paid. I don't think he's entitled to a lien. And so let's just start with the basic idea that a mechanics lien is there for licensed professionals who have provided services and materials to a project and made an improvement. And the lien is actually in the improvement. You cannot lien a property that has simply been for services that are simply repair or maintenance of the property necessarily. So repair and maintenance don't constitute an improvement. So it's for people that are framing, people that are roofing, people that are putting in landscaping, contractors, and those kinds of folks. And so when it comes to mechanics liens, and that was a really good answer. Is it Ramey? Is that how you pronounce it?
It is Ramey, such as Do Re Mi, just R-A-M-Y, Ramey.
Yeah, Ramey. And so, like I said, I think that the especially because it's being done with the permission of the homeowner, there are other legal avenues to get compensated. Things like unjust enrichment, something that is called quantum meruit, which is a fancy way of saying unjust enrichment. So you shouldn't be able to take advantage of a person who has improved a property of yours and be able to enjoy all the benefits of their labor and their money. Now, under certain circumstances, I think it would be possible that if this buyer, with the knowledge and permission of the homeowner, brought in those people, brought in a contractor or a subcontractor or a laborer or a roofer or a landscaper, and those people made improvements to the property, I think that there would be an argument that those folks might be entitled to a lien, just because of the knowledge of the property owner about the work that's being done. And that gets to another issue sometimes you get with mechanics liens, which is, well, let's say that you've got a mechanics lien, got a person that's done some work on a property and is entitled to a mechanics lien, but the person that contracts with them does not actually own the property. Let's say that they are a tenant. They are a tenant. And so the tenant has contracted with this person to do the work. And so it's clear under the law of mechanics liens that somebody might be entitled to a mechanics lien, but the question becomes, well, what does that attach to? Because normally with a mechanics lien, what is being attached is the fee simple ownership of the property. And if the person who is contracting for the work doesn't own a fee simple interest, but they have a recognized interest in, say, a leasehold, what is being attached? And it's generally the rule that you can only attach as much of an interest in the property as the person who is responsible for payment for the work owns, which means you would have a mechanics lien only on the leasehold interest. which is sort of useless, actually. Now, that is not the rule in a commercial property. So I don't know if anybody out there owns a commercial property, but if you own a commercial property and you have a tenant who hires folks to come in and make improvements to it, the law is a little more lenient toward lien holders. And it's almost like a strict liability standard where they will allow the owner of the property to, in a sense, be responsible for payment of the lien, because they will allow the lien to attach to the fee simple interest in the property. And so why does it matter, right? Why does it matter what the lien attaches to? Well, somebody remind us of the purpose of a lien. What is the purpose of a lien? Any kind of a lien, a mechanics lien or any kind of a lien. What is the purpose of it? For the payment of a debt, right? It's an interest in a property to secure the payment of a debt. And if the debt is not paid, then the property can be sold to pay the debt. So a mechanics lien holder can force a sale of the property to pay the debt. And when we talk about priority in a moment, we'll revisit that. But if you have a lien and you're going to force a sale of the property, what you want is to be attaching the fee simple interest to the property so that the buyer of the property actually owns the property, right? If you're only attaching a leasehold interest, nobody's going to buy that because nobody is interested in just simply buying a leasehold interest in a property. So that was a little bit into the weeds right there at the start. So let me back up and kind of get into some of the basics of mechanics liens. So I like to think of mechanics liens in terms of 3 P's. 3 P's. Perfection. So how you actually get your lien and get it perfected. Priority. And I've already alluded to the concept of priority. So priority for liens just simply means who gets paid first. If there are several liens on a property, who gets paid first? And mechanics liens have a different rule for priority than other liens do. So that's why mechanics liens are a big deal to title companies, right? Because if we have a loss, if we've insured a lender and there is a loss of priority to a prior mechanics lien holder, that's a claim against the title insurance company. And it could be very costly. In fact, some of the things I'm going to talk about today were changes to the rules for priority that took place after the great meltdown, 2008, 2009. If you lived through that, you saw lots of builders go out of business. They couldn't pay their subs, they couldn't make any money, and they went bankrupt and went out of business. And in their wake, they left a bunch of mechanics liens because they just weren't paying their bills. So title companies had gotten a little lazy back then, and we weren't doing our jobs necessarily. So it resulted in a bunch of claims against title companies for mechanics liens. So I'll talk about that a little bit. And then the other one is protection. And I'm going to just talk about, with that briefly, a statute in Utah that exists for the protection of innocent homeowners that most people don't know anything about. But I'll talk about that as well. So let's start with this idea of perfection. So the law gives you the lien, right? So if you meet the description of who is entitled to a lien and you've provided materials or made an improvement to the property and you haven't been paid, the law says you have a lien. So the law, the lien is provided for by the law, but the law says that the lien holder has to do certain things to perfect that lien. And specifically, there are two steps to the perfection of a lien. And understand what I mean by the perfection of the lien. If the person claiming the lien does not go through these steps, and then they try to enforce their lien, they can't. They have no lien. So when I say that the lien is statutory, this is what I'm talking about. You have to do the things that the law requires to perfect the lien, or you have no lien. And at some point, as I go through these rules, you'll see that these are a lot of these steps are time sensitive, meaning, yeah, I didn't do what I was supposed to do to perfect my lien, and I tried to enforce it and I found out I couldn't, but I'm going to go back now and do that. I'm going to go back and perfect my lien. It might be too late. You might have lost the ability to do that. And so this is what I mean by perfection of the lien. And it's a two-parter. And one has to do with the state construction registry, and the other has to do with recording. And they are two distinct steps. So I don't know how much you know about the state construction registry. If you are a builder or are married to a builder, or married to a subcontractor, one of the trades folks, you know about the SCR. Or if you're a supplier of materials to construction or to remodel projects, you know about the SCR. So the SCR is a database. It's like an electronic bulletin board, and it's maintained by the Division of Professional Licensing. And everybody that does work on a property, from the contractor down to the framer, if they want to have a mechanics lien, or have the potential for a mechanics lien going forward, they have to go to the SCR and they have to essentially stake a claim. They have to put the world on notice that they are on the job, they have provided labor or materials to this project. And the way they do that is through what's called a preliminary notice, And so there are several different interfaces for this state construction registry. Contractors get on it, subs get on it, title companies get on it, lenders get on it, but the public can get on it as well. And so let's say that Vickie is building a new house, and she just wants to know who's filed preliminary notices on this property. She can go online, right? There's a public interface function. She can go online and see who's filed preliminary notices. And there could be dozens of these PNs filed against this property. So the big suppliers are always going to do it. The Bowman Camp Steel, the people supplying Whitewater, people supplying appliances and things like that. They're going to go on there, but they're going to file their preliminary notices. And then the contractor will do it, and the subcontractors will do it, and the laborers and the framers and the landscapers, everybody that's doing work on that property will file one of these PNs. And that's the first step in perfecting the mechanics lien. So because of the way priority works, title companies look at this on every transaction that is new construction, or in which that they have knowledge that there has been some sort of repair, remodel, or rebuild of the property. And so there could be dozens of these. The second one is probably better known to people, and that is recording with the county. So you'll see mechanics liens recorded at the county recorder. And because that's the one that most people are familiar with, most people think that that's the way that liens are perfected. But unless the lien holder does both of these, they don't have a lien. And so if they record at the county, but they have not filed at the state construction registry, they don't have any lien rights. So they have to do both of these. And these things are the things that are quite time sensitive. So for instance, the preliminary notice at the SCR has to be filed within 20 days of commencement of the work on the project. The recording has to happen, and it kind of depends. There's actually a two-part standard, but let's just say, for ease of purposes, that the lien holder has 180 days to file, or excuse me, to record at the county to preserve their lien rights. So this is what I'm saying. If I've not complied with that, I've not complied with that. So I've done this first part, right? I'm a contractor. I've done this first part, and I did record, but I recorded 100 days, or excuse me, I recorded 7 months after. Well, maybe that's a little confusing. The 180 days begins with what's called substantial completion of the original contract. So really what triggers the 180 days is the certificate of occupancy that's given by the city for the house, for the new house. And the certificate of occupancy is really an acknowledgement that this thing is pretty much done, right? We have substantial completion of this property. It is now habitable and you can move into it. So if I've got a builder who files his construction or his notice of mechanics lien 190 days after that certificate of occupancy, they have no lien rights because they have not complied with the statute. And there is another important time-sensitive part of this part of it, this recording part of the perfection. And it's this, that if the lien, let's say that the lien has not been paid, and they usually are, because a title company, before they're going to close that transaction and issue an owner's policy and a lender's policy, they're going to make sure that that lien has been paid. But if for whatever reason it hasn't been paid, then the builder has to start a lawsuit to enforce it. And they have another 180 days. And so from the point after which they have actually recorded their lien, they have another 180 days to start a lawsuit, to enforce the lien, and to record what is called a lis pendens. And a lis pendens is a notice of pending legal action. And the purpose of the lis pendens is to put the world on notice. Hey, this thing is going to court. This property is involved in a court action. Don't buy it. Don't loan against it. And maybe not even rent it. I don't know. That could be a potential problem. So if they don't do that, then their lien is time barred and they no longer have an enforceable lien. Now, that's not to say that they can't get paid. So if I've done work for somebody and I want to get paid, but I don't have any lien rights because I've been dumb and I haven't perfected my lien, I still have other avenues to sue them. So I can sue them under a contract action, or again, an unjust enrichment or a quantum meruit theory or something like that. So it's not that I'm out the money. It's just that I can't get the money through a lien proceeding. And so it's incumbent upon these people to know the lien laws so that they can protect themselves from not getting paid. So, and technically speaking, and maybe this is the one thing that you'll learn today, and I don't really know why it's important, but there is no such thing as a mechanics lien under Utah law. meaning it's not called a mechanics lien. It's called a construction services lien or a pre-construction services lien, because it's always been a little odd that mechanics, actual mechanics, right? People who work on your car, they're not entitled to mechanics liens. So Ramy, I'm glad you enjoyed that. Yeah, they're not actually on the list of people entitled to mechanics liens. Now they might have some other kind of lien, but it's not a mechanics lien. So in Utah, we're always going to refer to them as mechanics liens, but the actual technical term for these is construction services liens or pre-construction services liens. So, okay. How are we doing on time, Julie? So, any questions on that idea of perfection? Are people still awake? Ramy, I can see he's awake. Vickie, are you with us still? She's nodding.
Sorry, I couldn't unmute. I am.
You're okay.
But I do have a quick question. So we're in new construction. So if you file a lien, and then you say you have 180 days after occupancy, and so the house has probably already been purchased, how does that all fall into place?
Well, it's a really good question. And so it is possible. It is possible for you to buy a property and to have been there for, because most construction contracts will use that certificate of occupancy as sort of the trigger for the close of the property. So builders got to perform within, say, 15 days of final occupancy. So now let's say that the CO has been issued and it's 15 days and you've moved in. It's possible that in 5 months from now, you're going to get a nice little love letter in the mail that says, oh, yeah, we did work on this property and we didn't get paid. And so we're going to lien your property. Well, that's when you're going to go to your title company and you're going to say, what the heck? I've got a lien on my property. And if the title company didn't do their job and make sure that everybody that had filed a PN on the property had been paid and had given the title company a lien release, then the title company's on the hook for that. Then they're the ones that are responsible for it. So when we close new construction, we're going to this SCR several times, and we are going to every single entity that has filed a preliminary notice. And we're saying, have you guys been paid? And if you have been paid, we need a lien release, and we're getting a lien release from them. So if the title company hasn't done that, then you've got a claim on the title company. Now, it's important right here to talk a little bit about title insurance. And so there are different kinds of title insurance policies for buyers of property, for owners of property. Let's just talk about a standard policy versus an extended policy. Standard policy versus an extended policy. The extended policy, maybe you know by a different name. It's called a homeowner's policy. Homeowners. And if you look at the REPSIs, so the state REPSIs for existing residential or for new construction, it requires the seller of the property to give the buyer a homeowner's policy. Well, a homeowner's policy is an extended policy, and for purposes of this class, there is one big distinction between a standard policy and an extended policy. Does anybody know what I'm getting at in context of this class? An extended policy gives the buyer protection against mechanics liens. A standard policy does not. And so This costs a little more, 10% more, but it's absolutely critical to get one of these in new construction. It gives other kinds of protections, right? As the name implies, there are several different forms of protection that you get here that you don't get here. But the biggie is mechanics liens. So if you go to your title company and say, hey, I got this lien showing up on my property, and the title company says, well, you've just got a standard policy, then you're a little hosed. And this is where the last thing I'm going to talk about is this concept of protection for innocent homeowners. You still might be okay, but you want to make sure that you're using a reputable title company, that you've got a builder who is giving you the homeowner's policy, and that you'll have coverage against mechanics liens. Now, if you've got a builder who just says, no, I won't pay the extra 10% for the extended policy, I will only buy a standard policy. Well, I think that that's a little suspicious. Makes me think that the builder is, I don't know, it's a little cheap, maybe a little cheap, because it's just such a minimal cost to get that homeowner's or that extended protection, that if you've got a builder that absolutely says, no, I'm only going to pay for this policy, not that policy, have your buyer pay the difference. Have your buyer pay the little bit of difference to buy this extended policy for themselves so that they get that protection. And if I were to go through the other protections you'd see, you really almost always want a homeowner's policy as opposed to a standard policy. So, Vickie, the long answer to your question, but did that answer it?
Yep, it did. Thanks.
Yeah. And things are pretty good right now, right? We're not seeing a lot of mechanics liens claims. Builders are not having a problem paying their bills, although they're having problems. Does anybody in here know what kind of a peculiar problem these home builders are facing these days?
Yeah, we can't get materials. We can't, prices are raising faster than you can keep on top of them. And you can't get framers. Nobody wants to work anymore.
Exactly. And so a property that was put under contract 6 months ago, at $550,000 is now costing that builder $600,000 to build because of costs. So now the builder has to either eat $50,000 or go back to the homeowner and say, or the buyer and say, I can't build it at that price, right? I'm either going to have to cancel the contract, or you're going to have to come up with more money for this house so that we can pay for it and make money on it. And it's kind of a real sticky situation that these builders are in. There are a lot of builders now that are deciding right now not to build custom homes, but to build only specs, right? So that they can sell the property for what they're into it, plus their 10% or whatever they're accustomed to getting on it. And so, yeah, Vickie, and the other thing, and we've got a son that's a builder, and so we kind of have heard stories. A lot of these builders are getting lumber stolen from their sites. So our son was telling us the other day about one of his Finnish carpenters came to him and said, hey, there's been a guy wandering around your property, and I think he might be stealing lumber off your site. And sure enough, they caught this guy stealing lumber and called the cops, and the cops approached him and said, hey, you got to take that stuff back. And he claimed that it was just firewood, that he was just picking up odds and ends for firewood. But it was 2x4s and 2x6s, whole lengths of 2x4s and 2x6s, which is pretty expensive firewood, right? So people are getting lumber and materials stolen from their sites. So anyway, yeah, it's a pretty interesting time to be in the building business. Materials. So a 4x8 sheet of plywood's gone up from $15 a sheet to nearly $100 a sheet, which is pretty crazy. So, okay, let me talk about.
So I have a question.
Shoot.
Why do title companies even offer a standard policy? I mean, period. Why not just only, exclusively offer, the extended homeowners policy? What's the purpose of a standard policy?
Well, and it's an underwriting, it's a kind of a complicated underwriting question, but we default to the homeowner's policy every single time. That is our default policy. So it would have to be a particular circumstance that we would even issue a standard policy. And the homeowner's policy is only available to naturalized individuals on 1 to 4 family residences. So we can't issue an extended policy to a buyer that is an entity. So let's say that the entity is an LLC or a corporation. That's not a naturalized individual, and so we can't issue the policy to that entity. And it's an underwriting problem. And we also can't issue it on raw ground, and so it's got to be a 1 to 4 family residence. Now, it is possible to issue the standard or the homeowner's policy at an additional cost, and so you can buy an endorsement. So an endorsement is a little bit of money, like $25 or $30, that you can buy to issue the homeowner's policy, against the underwriting standards. So there are some circumstances under which our underwriters will not allow us to issue the homeowners. But for most individuals, most private individuals, so they're always going to qualify for the homeowners. So good question. So let me talk about this concept of priority. And I think most people know what I mean by priority. So if you've got multiple liens on a property, the priority rules mean, well, who gets paid first? Because there's only so much money from the sale of the property to go around. Well, the general rule of priority is what's called first in time, first in line, first in time. No, first in time, first in line. So that's the reason why we record. That's why documents are recorded. The recording establishes priority. So the first person to record is the first person to get paid. The second person to record is the second person to get paid. Well, there are several rules that buck that rule, right? That don't go according to the rule of first in time, first in line. And mechanics liens are one of those liens. So the priority rules for mechanics liens are different. So the priority for a mechanics lien is established not by the recording part, right? That does not establish priority for a mechanics lien. What establishes priority is the preliminary notice, the very first preliminary notice that's filed with the state construction registry establishes priority for all mechanics liens to come. So let's say the very first person that comes in and files a preliminary notice is a big Still. What was the Bowman and Kemp, right? Bowman and Kemp Steel. Bowman and Kemp. They come in and file a preliminary notice. And what a lot of these folks do is they'll file, and it's actually improper, but they will file a lien even before they have furnished equipment. So a builder has gone in, Bowman and Kemp, and placed an order, for materials on a property that they're going to start in a month or two. Bowman and Kemp will go in and file their PN, even though they haven't actually issued any or provided any materials. I'm making it up.
Well, Bowman and Kemp, you can't use it and say that that's what they do.
Yeah, they do.
Oh,
I'm having a discussion with my bedmate. That's what they
all
do.
of our vendors do that, like Geneva Rock and all of those. As soon as we open up the account for each of the lots that we're building on, they immediately file on them.
Yeah, and technically you're only supposed to file if you've actually provided the materials or the labor. But they have staff, that do this, and they just make sure that they get their PN filed. But that does not give them priority over other mechanics liens. So the priority rules in Utah say that all mechanics liens are on equal footing. It's just that the very first PN establishes priority for all of the other mechanics liens. So if Bowman Kemp or Geneva Rock comes in and files their PN, and then there are 50 other lien holders, and this thing really goes belly up, and they have to foreclose and try to get paid, they all are on equal footing with each other. So Bowman and Kemp doesn't get any priority just because they filed first. So they're all on equal protection or on equal footing. And the reason why that this is an important thing for title companies to pay attention to is because if you've got, let's say that you've got all of these PNs, and then you record a construction loan, right? And you record the priority of the construction loan. It's behind all of these folks, meaning it's lost its priority unless the title company has made sure that each one of these people has been paid and has signed a lien release. And there are different kinds of lien releases that we won't get into. So that broken priority means that they're not in first position, which is what every lender needs to be, in first position in case they have to foreclose. So that's kind of a quick rundown on priority. Now, priority used to be different. Priority used to be established by first work commenced on the property. First visible work commenced on the property. And visible work on the property meant you go in, you start to excavate, you dig a hole, or you go in and you drop off lumber or materials, or you park your equipment on the lot, right? That's what established priority for the mechanics lien. And when I said the title companies were lazy and we weren't going out and inspecting property, what I mean is we were not going out and inspecting properties to make sure the work had not commenced on the property before we recorded the construction loans. So we were losing priority. Our lenders had lost priority, and it cost millions of dollars to title companies for losses. And so that's why we said, well, this is cumbersome, to have to go out and inspect every property. I remember when I first started to search title, what we'd have to do is go out to a property and we'd take a newspaper, right? Because that's the only way we could establish the date at which we were taking the picture of this lot. You'd go out, you'd hold up your newspaper and take a picture of the property that showed that on this date, no construction had started on this property. And once in a while we would go out, and you'd go out and there would be materials dropped on the property, or there would be the equipment. And we'd have to go back to their builder and say, get your stuff off the property, or else you're not going to get a construction loan. We can't insure it. Get your stuff off the property so that we can take a picture of it and prove that work had not commenced. And that's what we stopped doing. We stopped going out and doing physical inspections. And so we said, that's too cumbersome. Let's use this SCR. We had the SCR in place already. Let's use that to establish priority. And it has worked quite well. It's always being tweaked and it's always being changed a little bit, but it's actually worked quite well. And so it's a good system. So the protection part, and this is the part that really nobody knows about unless you are in the business. So Vickie, you sound like you've got some experience. Are you work with builders? You married to a builder? Or are you a builder?
I'm married to a builder, and my son, actually, we work through you guys a lot. It's Overland Homes.
Oh, good. Well, do you know what the Lien Restriction and Recovery Fund is?
I do. I've heard about it. Yeah. I haven't
Yeah.
had to use it because we use reputable subs. So hopefully I never have to.
Yeah. Let me tell you about the Lien Restriction and Recovery Act. It's kind of like what you have as real estate agents, and we have something similar to it as a title company. You know, you pay a little bit of money every year into a fund to protect the public against the bad acts of other real estate agents, for instance. You know, I don't know what yours is called, an education. I think ours is called the education fund or something like that. But builders and well, let me start with the first part of it. And so the law says that if you are an innocent homeowner, so Vickie, let's say that you've bought the property, you've got a standard policy, and a mechanics lien shows up. So the title company says, we're not going to pay for that. The law says if you are an innocent homeowner, then people cannot lien your property. And there's it doesn't actually call it an innocent homeowner, but that's essential. That's the essence of the statute. And what the statute says is that, Vickie, if you have used a licensed contractor, and it's important that you always use licensed people. And it's easy to check on the licensing of folks. You just go to the website, you know, Division of Professional Licensing, and you put the name in and see if these people have actually got the licenses that they're supposed to have. So if you've used a licensed contractor and you have a written agreement, and you've paid everything, you can prove that you've paid everything that's due under the written contract, and it is an owner-occupied property. So a house, a home. Then if you've done all of those things, you can go to Doppel and apply for what's called a certificate of compliance. And if they've found that you've done all these things, they'll give you a certificate of compliance. And anybody that has liened your property has to take their lien off. They have to remove it. They cannot lien the property. And there are wrinkles to each of these, you know, but essentially, if you meet those, they cannot lien your property. So, okay, so now you've got folks that have done work on your property. How do they get paid? You're just gonna let them get hosed? No, because we created a fund, right? We took lien rights away, but then we created a fund. And this is the Lien Restriction Recovery and Fund. It's referred to as the fund. And the fund is a pool of money that is financed through assessments against licensed folks like contractors and plumbers and electricians and other people that want to be beneficiaries under the fund. That they can, but they have to. It's not financed by the state legislature. It's funded from these assessments. So it's this pool of money that now the person that cannot lien the property but is entitled to a lien, they can go into this fund and get paid. And most builders will tell you exactly what Vickie has said. They've never had to go into the fund, and it's a good thing, because it's like pulling teeth to get money out of this fund. You got to jump through all kinds of hoops to get money out of this thing. And I don't know the statistic. I'm not sure how much money in that fund is actually used to reimburse contractors and subcontractors, as opposed to being eaten up in administrative costs. But it's hard to get money out of there. But the consequence is pretty significant. So if it's a contractor that has not been paying their subs, right? Their subs have had to go in. The fund will go after the contractor, and they'll go after the treble damages. And so if the claim against the fund was $20,000, they can go after the person responsible for not having paid those subs for 3 times that, 60,000, and yank their license. You don't hear a lot about that, but it used to be a bigger problem, you know, when during the recession, when everything was going to hell in a handbasket. So now I'm just about, does anybody have any questions on that? So Vickie, you know, you're not completely out in the cold if you've do have a lien that shows up on your property. So you can go to this Recovery Act and protect yourself. And instead of, we kind of got in the habit during the recession, instead of paying mechanics liens, we would help our homeowners kind of go through this and make application to the fund. And we would get the liens released that way. So, okay, one last thing, I think we're about done, is there is a statute that allows for an alternative to mechanics lien. And so let's say, Vickie, let's say that your husband has a real legitimate beef with his excavator, right? Or one of his tradespeople. They haven't been doing their job. And so he's not paying them. And so, you know, they lien the property. And he's trying to sell a lot, but now he's got this lien on the property. And he doesn't want to pay it off because he's going to litigate it. He's going to either negotiate or litigate it with these folks. So, you know, the property's being held in limbo. It's stuck there because he doesn't want to pay it because they don't deserve it. But he still wants to sell the house. He wants to sell the lot. Well, the law allows for an alternative security to the person claiming the lien. And there are a couple of ways around it. One really doesn't work. I haven't seen it happen in years, but the other is to hold money in escrow. So let's say that your excavator has filed a lien against this house for $20,000, but you want to go ahead with the sell, but it's got a lien on it. Well, what the law says is that you can hold money in escrow, and that escrow replaces the lien on the property. And there is a formula. So if the lien is 1 to $15,000, you escrow 2 times the amount of the lien. If it's 15 to 20, you do 1.75 times. And if it's over 20, then you do 2 or 1.5 times the lien. So let's just make this easy. Well, yeah, that's a $20,000 lien. So you would escrow 1.75 times that to 20,000, and I don't know what that is. Anybody know what 1.75 times 200,000 is? Anybody got a calculator? It doesn't matter. So let's just say that that is $40,000 or 35,000. You would hold $35,000 in escrow, and then the title company would hold that, and then you would record what's called a certificate of alternate security, and the lien would have to be released. The lien would then be released, and it would be replaced by that money being held in escrow. And we will do that occasionally. And that only works under certain circumstances. For instance, if there's been a lawsuit and a lis pendens filed for more than 90 days, we can't do that. So we actually did one of these for one of our hard money lenders who had made a loan. 2 of them had made a loan on a property up in Logan, and the contractor was not doing their job. So they suspended payment to the contractor, and the contractor liened the property for like $4 or $5 million. And they wanted to refinance. They were going to refinance it, but they couldn't with that lien on there. And so they said, well, let's escrow the money. And it was a substantial amount of money that was being held in escrow. But the problem was that there had been a lawsuit filed on it that was more than 90 days old. So they couldn't do this alternate security. And they took it to court, and the judge said, no, you can't do it. So anyway, but that is a remedy that occasionally a title company will use to get around a lien. But in most circumstances, you just want it paid off. Buyers are not comfortable closing properties where there are still recorded liens on the property, regardless of any of these other machinations. So it's always just better to get the thing off of there. So, and with that, I think we're ready to wrap it up. Who's got questions? Anybody?
Nobody? Well, we appreciate you guys attending the class today, and I hope each of you did what I said, learned something you didn't know before, or asked a question that you had in your mind. So just remember, we've got offices everywhere. We can help you out wherever you need to close, and we sure would like to do that. And we'll
Bill,
see you another time. Yes.
Who do we email our class rosters into?
Yeah. I don't see a link to submit our attendance or I just see this form, this PDF form. But I'm
And
not sure.
You can't write on it at all.
Okay, if you
Right.
click on it, in the link on the chat, if you click on it, download it to your computer, then you can email it and do everything you need to do.
Well,
But you
That's
still
what-
can't edit it.
but
That's
you
what they
can't-
sent me.
Okay.
So
Okay. Or let me see if I send that.
Which I still.
My email address. You can just email me your, because I know everybody that was here. Email me your name and your license number, and that will take care of that. And I will get those posted today.
thank you.
Thank you.
Thank you so
Anybody else
much.
have anything? All right. Hey,
Yes, enjoyed the class. It was great.
well, good.
Well, thank
I'm
you.
glad.
Yeah.
I'm glad. Have a great, where are we at? We're Thursday, so have a great weekend. We're almost there.
Yeah.
Okay, we'll see you next class.
See
Thank you
ya.
so much. Bye-bye.
Okay,
All right,
bye-bye.
Take care.